My name's Dave Bell, and I work for myself, but mostly work here in Missoula with Dan Belcourt, and we work for several tribes in Montana and Washington. And it's an honor today to be able to be here. I know there's a couple familiar faces, but not very many. Anyway, it's my honor to introduce the next speakers. I'm going to introduce all three, and we'll just move through each. I'll introduce Carrie first, and then we'll move through the speakers, and they'll transition between each other. So Carrie Huggs, she's a Crow tribal member from the Absaluki Nation. Carrie serves as the Fiduciary Trust Officer in Crow Agency with the Office of the Special Trustee. She has over 16 years of federal government service with 6 years of federal trust real estate experience. She attended Little Bighorn College and was in the Accelerated Bachelor's Program through the University of Mary in Bismarck. And Carrie provides Indian beneficiaries and tribes with quality service and expertise. The second speaker will be Lynette Tubbs. And Lynette is an enrolled member of the Cherokee Nation. She serves as the Fiduciary Trust Officer at Northern Cheyenne and the Rocky Mountain Regional Office, which is with the Office of the Special Trustee. Lynette has 12 years of federal government service as a Fiduciary Trust Officer, and prior to entering federal service worked at Wells Fargo for 12 years. Lynette's a graduate of Carroll College with a business administration and finance degree. And last, Francis will speak last out of this group of three. And Francis is the Senior Probate Specialist in the Tribal Lands Department at CSKT and has been there since November of 1990. She has served at the Flathead Agency and CKST for a total of 37 years. And Francis was born on the Flathead Indian Reservation and is an enrolled member of the CSKT. She has an Associate of Arts degree in computer science from Salish and Kootenai College in Pablo, and has been trained in will writing with the Bureau of Indian Affairs and has scribed wills for the last 26 years. And she's also been a notary for the state of Montana for that same period of time. So we'll go ahead and move into, we'll have lunch, an early lunch that will be delivered sometime around 11, but we'll go ahead and go into Carrie's presentation first.
Good morning, glad to be here. Okay, I will cover the roles and responsibilities with the OST, and we do work closely with the Bureau of Indian Affairs. And at the field offices, we are the first point of contact with beneficiaries. Our beneficiaries are the Indian tribes and the individual Indians. Most of our time is communicating with our beneficiaries, and we do, like Deb mentioned, we do have access with the BIA systems and our own systems to properly and accurately inform our beneficiaries. And the main purpose is our financial responsibility for the trust assets. Our services also encompass the estate planning portion. We do educate our beneficiaries about APRA, the conditions of APRA, and the difference with having wills. And we do provide reports to our beneficiaries that do need to know their asset information. With the estate planning comes financial literacy, and that is really important. Some tribes do have judgment award accounts and that do hold larger balances, so we try to provide the financial literacy part of it with land buyback and the amount of funds that flow through these IIM accounts. The financial part of that, literacy part of that is very important as well. We serve as a liaison for our beneficiaries when we do communicate with the BIA. A lot of individuals know about the undivided interest that they may have acquired, but they do not understand how to read their reports. So we are able to sit down with them, explain what undivided interest is, where their land may be located. If it's on different reservations, we're able to identify what type of interest they inherited and who they may have inherited from. We do also, from the fields, we do have a lot of input in coordinating any reform efforts there are in Indian country that helps with initiatives that may be out there. Let's see, and we, like I mentioned, we do work closely with the BI, and the BI is responsible for the actual management of the resources. It may be surface, subsurface, minerals. There are some reservations where different acts apply to different reservations. For Crow, there are 2 different acts. The first act, they were able to acquire mineral tracts, and they are able to either through the probate process, through APRA or by will, certain minerals can be devised to an heir. The second act for Crow reserved all those mineral interests to the Crow tribe itself. So there's different acts for different locations, so it's good to know where they have acquired and which act it may follow. The BIA does cover, provide all the contracts, leases. They do communicate with their landowners. Our systems communicate, interface with each other, so if an individual updates their address on our side, it interfaces to their TAM system where they are able to get notices for leases, surface leases that may be coming up, right-of-way type encumbrances that may be issued to them for consent. BIA is also responsible for title, the ownership. Title plants are located regionally, and the thing with BIA is for our region, it is located in Billings, Rocky Mountain Regional Office, and they would have to communicate with another regional office to get that title updated if it's through conveyance or through probate. They are not able to change the title from our one location. They have to interface with each other and change title for each. It's very separate. Their regions are very separate on the BIA side when it comes to ownership. The BIA also handles a probate process working with OST and Office of Hearing Appeals, and Human Services is also a service provided by the BIA. The individual, like I mentioned, they should be responsible for knowing their undivided interests. Not a lot of people understand what undivided interest means. We do have instances where they believe the whole parcel is under their own ownership, so we do have to explain what that undivided decimal interest means in a certain tract. There are a lot of owners that do not know how to read their land descriptions. That's another thing that we are able to explain to them. And as natives, most of them are visual learners. So what we would do is we're able to work with BIA and provide them aerial photos of the location of their allotments. And with those photos and their reports, they're able to meet with a will writer and start thinking about who they are going to devise to, and that way they are better prepared to sit down with somebody and create a will. Let's see. There are cultural barriers, just so you understand. A lot of cultures, especially within the women folk, they will not make eye contact. with another individual out of respect. And another barrier may be language. A lot of natives still speak their language. They will understand English, but they have a hard time interpreting some of the terms, or any kind of if they want to explain something, it's better for them to say it in their own language. So it might be necessary to have an interpreter there, and that helps them translate what their intention is for their will. So that's another thing that you might want to be aware of. But we are able, as FTOs, we are there and we're able to maybe recommend or be there and assist in some of those situations. So let's see. When writing a will, the individual should be prepared in knowing the heirs' legal names. There are many individuals with the same names in Indian country. So it's very important that they know their date of birth. If they do know their enrollment number, that is also a plus, but most of them do not know their grandchildren's enrollment numbers. But the date of birth is really important because we do have a lot of same names across Indian country. They do tend to name each other after each other, so that's just something, it's part of our culture. So it's really handy to have that date of birth is really important for those purposes. And they should be able to identify all their children, even if they're adopted in, adopted out, if they're deceased. We do have a lot of cultural customs where they claim they adopted them, but it's not legal. There was never nothing through the court system where there's a legal document to record that. And I think that's where a will is important, because they will be able to devise those interests to that certain individual, because there may not be a court order for them to be their child legally, but they did culturally adopt them in. And there is a lot of that throughout Indian country where grandparents may raise a grandchild for whatever reason. So that is really important to know that. And here is where I get to introduce Lynette. She will cover a lot of the information in more depth details. Like I mentioned, there is a lot of difference where they do not understand beneficial and title, what the difference are with the two, if they have one type of ownership versus the other, or both. We have to explain a lot of that, and it's really beneficial for them to stop by the office and cover their information before they meet with a will writer. So I thank everyone for coming in. Any questions?
Can you all hear me? Good morning, it's a pleasure to be here. I have to put all my notes out here, so give me a second. I'm Lynette Tubbs. I've worked with the federal government since 2004 as a fiduciary trust officer. And what we're going to go over right now is what we do every day. This is when we meet with the individual allottees and the tribes. We discuss this, we do estate planning. So if I get going too fast, or if I use a term that is an acronym, just raise your hand and I'll explain it. And I talk really fast. So if I'm going too fast, just let me know. The tribes in Rocky Mountain region, the federally recognized tribes in Rocky Mountain region are all of the Montana tribes, except for Deb's tribe, Salish Kootenai. They decided they want to be in a different region. And we also take in the Wind River tribes. So that's the federally recognized tribes that we deal with here in Rocky Mountain region. And what Carrie was saying, the Bureau of Indian Affairs, when they manage the land, they're only managing the reservation in which they're at. So for Northern Cheyenne, the Bureau of Indian Affairs is only going to handle the land management for Northern Cheyenne. The nice thing about OST is we see everything, and we'll answer or try to answer questions from across Indian country. Another thing that Deb pointed out is many of our beneficiaries will have land throughout Indian country. They may have it in Alaska, Navajo, over at Fort Berthold, in Oklahoma. So when we're dealing with it, there might be different probate codes that are addressed with that, and I know the judge will talk about that, and we get into that later. Fractionation is a huge issue for us to deal with in Indian country, and it just, even with the land buyback program and the new APRA, it still is fractioning at a rate that finds ourselves where we can't keep up with it. So doing a will, ensuring the beneficiary, the individual landowner, has the right designation to their heirs is really important. It also will help us reduce fractionation. And so what I'm going to start out with is the Rocky Mountain region, the tribes just in our location, and kind of show you how significant the problem is and how much land is managed. So let me get in here. And why it's important to do estate planning. The magnitude of fractionation is kind of illustrated here with this. So for the Rocky Mountain region, for surface tracts, they manage approximately 6.4 million acres. The tribes have about 3.4 million of that, and then there's allotted acres of about 2.7 million. That's huge, and that's just surface. When we look at Rocky Mountain region and you look at the mineral interests, tribes own about 5.3 million, and the remainder is allotted individual landowners. That's a significant amount of land to manage, and it is a huge effort for us because of how many individual allottees there are, undivided interest holders there are. Sometimes we don't know where they're at. In order to do the management, we have to provide them information. They have to give us consent. It's a monumental task. You can see that there are unique individual owners are 52,974. The number right down here that we provided before was 52,676,000. So just since 3 years ago to now, we, even with the land buyback, even with utilizing wills and even utilizing probates, we're still growing. We don't have a handle on it. We're not reducing it. It just compounds upon itself. There are, in the Rocky Mountain region, there are 37,149 individual IAM accounts. That's just what we manage here in Rocky Mountain region. And in that, there's over $46 million in those accounts. Out of all of those, there are 3,940 people that we do not know their whereabouts. And this is a task that Carrie and I work on every day, posting lists, talking to people, asking if they know where their relatives are, because it's vital that they have the information for their accounts, but it's even more important for the Bureau to know where they are to help manage the land.
Lynette, are you saying that they have accounts that have money in them, but they themselves are missing?
Yes, and there's a lot of reasons for that.
Okay.
So out of that number of whereabouts unknown, those are individual Indian money accounts. Somebody owns land or has money in those accounts. Sometimes it can be a penny, sometimes it can be thousands or hundreds of thousands of dollars. And there's some reasons for that. Some people don't want to be found for whatever reason that they have. Some people get irritated when they get their statement and all they see is one penny. So sometimes it's not worth it to them to update their address because we have a lot of transit from place to place, and they have to call in and update their address. So sometimes they won't update it until right before money is going to come in. And for a lot of the reservations, they know annually when it's going to come in. For Northern Cheyenne, the biggest money producer is range payments, so cattle grazing. They all know that it comes in about February 14th. So a lot of our whereabouts unknown will be whereabouts unknown right up until February 1st, January 1st, they get their money and then they go right back on to whereabouts unknown. And some people are truly lost. Some people may not even know that they have an account because they inherited through a probate and we didn't have their whereabouts at the time they inherited, so they may not even know. They may not be connected with family or the reservation, so they're not having access to our list showing that their names are out there, so they may even be unaware they have an account. The 52,900 plus IAM accounts, those are unique individual owners. And we say unique because part of the Bureau's and the OST's responsibility, the federal government as the trustee of these lands, is every time a person inherits through a probate or through a purchasing or getting a gift deed, we have to keep track of every single one of those documents. And so somebody might inherit through multiple probates in a single allotment. So they might have 3 or 4 legal documents they inherited for. So that will increase how many owners it looks like are on there. So we go by the unique. So if they haven't, one person has an interest in there, the unique only is counting them once, while they may have inherited multiple times through it. So you may hear us speak about unique in undivided interest holders, and that's the reason why, because we can see the number of documents that have transferred into that allotment, which will be much higher sometimes than the unique ownership interest. So don't be thrown off when we're saying that. We know what it means. It's just counting how many people are on there in a unique ownership interest. And it's an issue because it continues to grow. As somebody passes away through the APRA Act, it continues to grow and grow, which is why we do the education out in the field to encourage people to look at their trust assets and determine how they want it to be passed on their death, so that we can hopefully reduce the fractionation, because it, as you can see, is a monumental task just to manage the land. I didn't get the clip. Let me grab this so I can catch up. So what is fractionation? Fractionation is a continually growing, increasing number of owners per land parcel as each person or as each generation passes. And it's not uncommon to have 50, 60, 100. We even have some of them that, if I'm not mistaken, are reaching the number of 1,000 people on one parcel. And everybody knows the more people you have on it, the less able you are to manage it. When we work in group settings, everybody knows the more people you add to the group, the less you get accomplished because you have different opinions. That's the same with this. It's impossible to keep all of their addresses updated. One of the things too is the Bureau of Indian Affairs, the superintendent can step in for minor children because they're all supervised accounts, and then we've got adults that we supervise under adult in need and non-compos mentis. So the Bureau, the superintendent, can step in on the behalf of those individuals and act for consent or disapproval of consent when managing the funds. But for everybody else, we need to get through federal law. There's sliding scale of consents that are necessary in order to enter into leases. And as you can see, it's a huge task to get this number of individuals to agree to consent to leasing. Fractionation is hard for individuals to understand. So what we do out in the field, because we're so visual and because this is the only way I can figure out how to explain it, is we tell them, think of your tract of land. Go anywhere on it, any of the 4 corners in the center. Pick up that handful of soil. You don't own any one single granule of sand in that soil. you own your undivided interest in the entire handful along with everybody else. And that kind of gives you an idea. You don't own a small postage stamp of land for yourself over here. You own your undivided interest in the entire parcel of land along with everybody else. So that's kind of where the consent is and how we explain it when we're talking to our beneficiaries so that they can understand it a little bit more easily. When the allotments were originally allotted out to the individual original allottees, they had 1/1 ownership or 100% ownership. And as that original allottee passed, and the ownership was and continues to be distributed among the heirs as each passing generation, of course we get an increasing amount of owners on that. Many people will think of their undivided interest as a acreage, and we tend to try to get them out of that because of how the ownership is, how that example of you own your undivided interest in that handful of soil versus any one granule. It's tough for people because they'll say to you, I want to give in my will 5 acres to this individual, 5 acres to this individual, and they don't own a 5-acre parcel 100%. It might be a 120-acre tract or 160-acre tract, and they only own 1% undivided interest. And so really what they're giving through bequeathing to their heirs is that undivided interest. And so when people are talking about specific acreage, we always discourage them from that because that's not how it's going to be devised. They are going to own their undivided interest in that entire 160 acres, and so they may not have a full 5 acres in that to give because their undivided interest may be too small to equate to a specific acreage. So how do we explain it? Because still, when we're talking in words, if we do it every day and we're talking about wills, we get it. We talk about it fast, we go through it and assume everybody else is catching up. So we use this illustration to kind of show to somebody how the generations work. So the original allottee had a 1/1 interest or 100% ownership. They had all the income that came off of that, generated off that from leases. They owned the land. And when they pass, and we're going to assume in this one, they didn't have a surviving spouse, and all the children survived them. If they had 3 children, the second generation would have a 1/3 undivided interest in that entire allotment. And then when you look and we keep going down, and you see the next generation, if the middle child passes away, and let's say they had 3 children, you can see they'd have 1/3 of a 1/3 undivided interest. And so as we go all the way down through the 6 generations, kind of following the chart here, the last generation would have had a 1/432 parts of this ownership. So when they get down to the 6th generation, they would have had, I've got it written down here, let me see if I can follow it all the way through. They would have had a 1/3 of a 1/4 of a 1/4 of a 1/3 of a 1/3 undivided interest. That's how we're getting to the less than 1%, and it's not uncommon to see in the next slides when you look at their landholding reports, a 0.00000 and then a number, which just shows you how significant it is because they're not really receiving income off of it because it's not the land may not generate enough for them to even have a monetary distribution, but we're still required to have an open IAM account for them. We're still required to follow all of the land holdings. We're still required to provide to them a listing of all the leases they have and all their land holdings. And that's where when I said sometimes your whereabouts unknown don't want to be found, because they may not have any income generating, and they may never have income generating because of how small the fractionation is. And but we're required to send them a statement quarterly.
And if there is a spouse?
The judge will kind of explain this. So if there's a spouse and they pass away under the April law, no will, and their tribe doesn't have an approved secretarial approval for their own probate code, so that is an example where April would be surpassed by the Northern Cheyenne tribe. They have their own probate code, or Standing Rock has theirs. So if we're just following APRA, the surviving spouse would have a life estate if the pieces of undivided interest are 5% or greater. They wouldn't if it's less than a 5% interest. The only caveat to that is if they're actually living on an allotment that the deceased had a less than 1% interest, they are able to continue to live on that allotment for their lifetime, unless the tribe has a rule that says they can't, and that's just more technicality, but that's how it would work for a spouse. 5% or more, they would receive the life estate, so would receive the income off of that for their lifetime. Anything less than 1%, unless they're living at it at the time of death, they would not receive any income off of it. And you can see this really makes it even more important for our individual undivided interest holders to really do their estate planning, to make sure that they're getting it to the individuals they want, but also if they have a non-Indian spouse or their spouse, so that they can ensure the income that's generated from the land is actually going the way that they want to. So if they want their spouse to continue to have the income, a will is the only way, if it's less than a 1% interest, to ensure that they're getting all of the income generated off of the land holdings.
1%, not 5%?
Less than 5%. Sorry.
That's all right.
Thank you for correcting me on that. So how do they know? What do we look at? And probably the most common thing that we do, or one of the most common things we do, is we go through the individual tribal interest reports. So when an individual is getting ready to do estate planning, we'll print for them their ITI report, and it gives all of the information, how ownership is titled, how much undivided interest they have, the legal description, the original allottee name, the allotment numbers. It'll tell them if they have surface or mineral or both. We go over these daily with individuals and really educate them so that they have an understanding what their land holding is, but then when they're talking about estate planning, they have all the information at their fingertips that they can provide to their preparer. We also provide to them the landowner's income report, and this tells them all of the income that's generated off their undivided interest, except for oil and gas, because we all know that you should know that oil and gas fluctuates based on volume and price, so we can't put on the landowner's income report what their estimated annual income is going to be from that particular parcel and lease, because it fluctuates significantly. So this is good. Why would you need to know that? Because some people will divvy out land. If they have it at Northern Cheyenne and they run cattle, they may want the child that's going to take over the cattle operation to have ownership in that land, but that's not going to produce that maybe income for that individual, or maybe it will, but maybe they own land down in Concho, Southern Cheyenne, that is mineral interest producing, and they want to make sure the other children have some type of benefit from the land that they receive, so they may divvy up the oil and gas to those children that aren't. That's just one example, but we kind of walk through what land they have, what the income is, and then they can kind of make the decision before they get to the preparer of their will of how they want it to go. We encourage them to meet with us, talk to us. We'll go through all of this so that they have time to understand it, so that they're not trying to make the decision when they're at your desk and you're trying to prepare the will. It can get frustrating both for the preparer and the individual if they don't have all of this set before they get there. And it's perfectly acceptable to let them know, if you're going to be preparing their will, what your expectation is when they come to your office. They need to know what land they hold. They need to know who they're going to give it to before. They need to provide you with the legal names and the birth dates, enrollment numbers if they have it, because it can be very time consuming for them to sit down. Some of the reports can be 20, 30 pages long, and as a preparer, it's difficult to have them trying to decide what they're sitting there. So my philosophy is when I'm talking to them is have it ready and to go, write down on your ITI report, be prepared so that when you get there, all you have to do is hand them that report. It says who you want, and then you can answer the additional estate planning questions. And remember, the federal probate is only going to probate Indian trust land and the IAM account. It is not going to speak to the home site lease. It's not going to speak to their bank accounts. It's not going to speak to their cultural items or if they have fee property. The federal probate that is done for Indian trust land is only going to cover the Indian trust land and the IAM account, which is why it's so important for the preparers not to think of Indian wills and estate planning. It's estate planning with Indian trust will writing as part of the complete preparation. Okay, so Carrie, you handed out this form because it's almost impossible to read from up here. And this is what an ITI report looks like. And we're going to go through it. So at the top of the page that she provided, she gave you the land area codes for all of the federally recognized tribes here in Rocky Mountain region. She also, if you'll know, they also talk about public domain land, and that is land for Turtle Mountain, the Cree, correct? For Cree. And when they did the allotments for Cree in the Dakotas, they did it in the time when it was summer, and several of the tribe were up in the Northern Territory. So when they came back down for winter, they hadn't been allotted pieces of property for them. So what they did is they took places throughout different areas. And for Montana, it's at Northern Cheyenne, Fort Belknap, and Fort Peck. So these are managed by the reservation in which the land area code is, but they actually belong to the Turtle Mountain reservation. Just kind of a fun fact that you'll run into. That way you're not confused by what's this mean on there, but you can find that. When we're going through the ITI report, the Individual Trust Interest Report, it'll have a listing of all their names, how they were legally known for title, and right under that is the most important part. There is the tract ID, and then it has a acronym of LAC, which is Land Area Code. In this case, it shows 202, which is Crow. You don't have to know what that number is because 4 columns over, or 5 columns over, it's going to tell you the land area of where it's at. So you don't have to know everybody's land area code. This form will tell you what that is, and you can see that right here that we didn't fix it. Should say Crow, not Fort Peck. Keep us on our toes there. But for 202, it's Crow, and the land area code should say Crow, not Fort Peck. You can also see the next one is prefix. Now remember, we can hold, not every reservation, but certain reservations, the individual beneficiary can hold mineral, can own surface, or can have both. So if you see a prefix of M, they have a mineral. And again, you don't need to remember that because right past the land area code where it said Fort Peck, when it should say Crow, it'll tell you if it's mineral, if it's surface, or if it's both. So we're a little redundant. You don't have to memorize the codes because they're right there. The next one is probably the most important, or is another part of the important when you're drafting a will, is the number. That's the allotment number. In this case, it says 13. And then the next one is the FX or the suffix, if it's been partitioned. So remember we said you got a 160-acre allotment. Sometime in the history of that allotment, if a parent had said, I'm going to give you a 5 acres of my allotment so that you can have a home site lease, they would partition it. So if the person held it at 100%, they would partition or break off 5 acres, and then we're going to give it a suffix of like an A. So if that had happened in this allotment, it'd be 202M13A or B or C if they partition it multiple times. And what it did is allowed that individual to get that ownership that the person had, and it's usually 100% ownership when you're partitioning, to give that acreage in that undivided interest, or in this case 100% to that child. And it we had to have a mechanism to keep track of all of that, and so that's why you'll have the suffix that's there. Now when you're drafting your will, the land area code, the prefix, the number, and the suffix is going to be very important to you. And I know Mr. Hargraves and will talk to you about when you're writing the will what you need to have there, but these are the pieces of the property that you need to. Then we go to the next column and it'll tell you the title plat. Carrie kind of touched on this when she was doing it. In this case, if it's in the Rocky Mountain region, it's going to be the Billings title plat. And when she was talking about transferring, so if somebody has title at Concho, which would be Southern Plain or Southern Cheyenne down in Oklahoma, their land area code is 801. Rocky Mountain region title plat can't update any title for land for another area. So they would have to coordinate with Southern Plains title plant in order to get it updated. It's important for us to know, we need to know that, because it becomes difficult when we're changing IDs. Sometimes if a person is not enrolled and they become enrolled, we have to get title changed. We'll have to work through multiple different title plants in order to get that completed, because the bureaus, like Northern Cheyenne, can only manage the property at Northern Cheyenne. What's kind of unique is Carrie told you that Crow had 2 different executive orders creating the tribal allotments. One with the individual being able to have the oil and gas, and then the second order stating they couldn't. Well, Northern Cheyenne, the tribe, has all of the minerals. So if you're working with Northern Cheyenne, the individuals are only going to have the surface portion of the property. They're not going to have any. So you don't have to worry about the severed, because it's already been severed and the tribe has all the minerals. Okay. And then again, the last column right here, the column that says resources, will tell you if it's mineral, surface, or both. Then we drop down, and the thing that is important, because a lot of individuals will only know the original allottee's name. So that'll be right underneath this area. There's going to be above the legal description, it'll say who the original allottee is. And Deb was mentioning in land buyback that there was a little bit of surprise on how much interest there was in selling. When I meet with individuals and they're talking about selling or land buyback, of course it's a voluntary program, but in some instances you have a varying degree. A lot of individuals that have very small fractionated interests were interested in selling. Some were said, I need to know which ones I inherited from my grandma, because she said never ever sell that, because there's an emotional or a historical or cultural significance to that allotment. So no matter how much money you offered them, no matter how small it is, they're never going to get rid of it. And a lot of them identify those, how they look at those allotments by that original allottee's name. So a lot of times when you're meeting with an individual and you're doing the will, they're not going to refer to the allotment numbers. They're going to refer to that original allottee, which is why it's so vital for you to have this ITI report when you're drafting, so that you can kind of identify and understand what they're talking about. The next thing down is the legal description, how you find it on a map. You can, even now you can look it up on Google Maps and pull it up. We go to the bureau and they can give us aerial maps. If you come to my office, I have a big plat map. That's the only way I can find it. It's just there, and if they need something more, we send them to get an aerial map. That's how people come in too. I want this piece of property up by X landmark to be given to this child. Or I want this piece of property that has the cemetery on it to be given to the child. In that case, if the cemetery isn't recorded within the title, we will send them to the Bureau of Indian Affairs. They'll get an aerial map. They can isolate it down to that. So pre-planning for an individual that has Indian trust land is very important. We'll help them. If they come to our office, we'll print it off, we'll go through it, we'll get them to the right BIA department if they need to have more significant information, if it's something that, based on the systems, we don't have enough information to do, so that when they come to you and you're drafting it, they have it all ready to go and you're not trying to figure it out or having to wait for them. It'll also tell, in addition to the legal description, it'll tell how many acres that allotment is. And then we'll drop down to the columns that say owner document. So right down here, this is our coding that tells us how they have inherited, the type. If it says I, it's Indian. The next column over is the interest type. Ownership type. It'll tell you how they, how we got it. Was it through well, I don't usually look at that one because it's more difficult for me. So the ownership type of T tells us it's tribal. Trust, sorry, I'm looking at different columns here. So trust. The next one over is interest. Do they have all? Do they have beneficial or title? Or do they just have title? Or do they have just beneficial? And in this case, when it says A, it means it has both beneficial and title. Interest.
Lynette, would you explain beneficial a little?
Beneficial. So when we were talking about life estates, so if somebody comes in and wants to do a gift deed, or if they're in their will going to give the land to their children, but allow the spouse to retain the life estate, that's beneficial. Mm-hmm. The beneficial is they're going to receive the income off that land that's generated off that tract for their lifetime. And then when they pass, that beneficial will automatically vest back into the title interest owner's ownership. So beneficial is really your life estate. It's the title of life estate. The CLS is the type. How did we get it? In this case, it says 11. That tells me it was a probate. We'll walk through for people if they have questions on how they inherited it. This is a quick way for us. Oh, it was a probate. We can look on our system. We can find out what probate they inherited from. Because a lot of times people will come in and they've inherited from multiple different probates, and they'll say, I want this child to get all the land I received from my mom. And I want this child to get all the land that I received from my dad. And my grandpa gave me this piece of land through as an estate, and I want this child to get that. Well, what we'll do is we can see from this that it's a probate, but that number that is there that says TC 116-998, that tells me the probate number. That's the actual document. So I can go on to my system, I can actually pull it up, I can look at the document, especially those that have been from 2004 or newer, they're actually scanned in. I can pull it up, I can actually read it, see the supporting documentation, and then I can write on that ITI report what interest. And sometimes they'll have multiple inheritance on that allotment from multiple different probates, and we'll write right next to them what it is so that they can identify it throughout the ITI report.
So I know you guys are super women and stuff, so I'm asking you if tomorrow we have this situation, because we've run into it, as you know, when they come in and they sit down and they say, I want to do that, can you do this for us tomorrow?
You can. You can't,
I know I can't.
Because it's
I'm
Privacy
asking
Act.
you.
I can do it tomorrow. One of the challenges that we see out there is with the budgets the way they are, there's less and less of us. So what the individual can do is they can call us. If they need it immediately and I'm unavailable, I'm working with somebody else, or I'm out on trainings, they can call that TBC, that Trust Beneficiary Call Center, and they would need to know their enrollment number, their social security, the date of birth, so that they could be pulled up because we need to identify them. And those individuals can actually go in and look at the system and pull that information up and tell you right over the telephone. So anybody that has access to the TAM system, the Bureau system, can actually pull it up, and we can give you any information that's encoded in there. And in this case, anything that is recorded for a document, inheritance, purchase or sell, or a gift deed, we'd be able to tell you exactly who it was, and in most cases I can actually bring the document up and read it.
And like if that's because you're gonna be at the clinic tomorrow,
Mhm.
right? And so if that happens tomorrow, would it be something that can be done?
If we have access to Wi-Fi tomorrow and it works, I can print it right there. They
Okay.
just have to identify it. And we will do
As
it
long
pre.
as it's 2004.
Well, and we're starting to see they're scanning more and more of the documents. We're
Okay.
seeing more old ones, but the ones from 2004, we can almost guarantee we're going to see it immediately because those were being scanned in as they did them. The older documents, I mean, we get questions from 1968. I had one the other day from I think it was 40. Those ones may not be there, and it may take us a little longer to go hunt down the actual probate file to look at who they inherited from. Usually though we can see, because how they do the BIA, the title work is done, we can get into the TAM system, and there's other ways we can get around to see whose it was.
Because I don't think we can do that quickly in our probate stuff. So
No,
that's why I'm like,
you know, there are some,
kind of-
yeah, there are some advantages, and I'll tell you, from when I came in 2004 as one of the big groups of FTOs that came in, individuals weren't getting statements. They didn't have a land listing. They actually had to come in here. The things were not scanned in. The strides that they've made is impressive, and it's all at a fingertip. And you can get access to it. It really, the customer service that we're able to provide to the individual landholders and the tribe is really amazing. From 2004 to now, what we've been able to accomplish. I mean, it's probably one of the things that coming from private sector where that was just commonplace, to coming in, watching that happen, and what we're able to provide to the beneficiary, we've come a long way, and it is pretty fast. We do have it at our fingertips. So yes, we could get it to you. The problem is getting to me and them and being able to do it. Sometimes you want it immediately, and we're helping other people, but there are other options that you can get it for. Okay, so to write it past the, when you look at the owner and the document, it'll tell you how you inherited. So if you inherited it before you got married, it'll have that name. If you inherited it after you got married, it'll have that name. If you changed your name with a court order and then inherited, it'll be there. So you can see all the names. Here's another place you can see all the names that the document was utilizing for your legal name for inheriting through that trust document. And when we were talking about the number, the probate number, that TC number, it might be a gift deed number, it might be a purchase of the property, recorded deed number, and those are a little bit more complex. We have to look those up to see how you purchased it, or what if you received it as a gift deed, but that's all at our fingertips too. Probably the most important piece is the aggregated share. So in this case, when you're looking, you go past the name and you look at the aggregated share column, and it says 1/54. That's your undivided interest. And then to the right of that, we give the decimal point. So in this case, it's 0.0185. If you move the decimal place over 2, they own a 1.85% undivided interest. That's where we're talking about the fractionation, talking about not thinking of it in the terms of actual acreage, but you want to think of it in as that undivided interest that they have, and this is where it tells you what their interest is.
What's the undivided interest in this legally described property?
Correct. In that 103 total acres, they have the 1.85% undivided interest.
And the 54 refers to how many interests there are, which is.
It's a
basically
fraction.
the owners.
It's their fraction. It doesn't necessarily mean, it doesn't equate to the number of owners.
Okay.
It's remember, 1/3 of 1/3 of 1/4 of that. So the way I explain it too is I talk about my grandfather, and I will not use great-grandfather, I will not use all of his kids because we'd be here forever. So he had an original allotment down in Oklahoma. He owned it 100%. He had 10 kids. He really actually had 18 with the adopted, but so the 10. And if child 1 inherits, he doesn't have a surviving spouse, they inherit its 1/10 interest. It's the same thing as that. As you go down and you keep going further, you could have 200 people on it and still have a fractionated interest of 1/54 or 1.8. Remember, and not everybody is going to have the same. You may own 10% while Carrie owns less than a 1% interest, and that's why you don't. It's your fraction of your undivided interest that you own. Does that make sense?
It does, thank you.
Okay. We tend to talk about it a lot, so we assume that everybody's following. So anytime if I'm using an analogy that doesn't make sense, make sure you ask me. So a lot of times the beneficiaries will come in and ask us to calculate how many acres does that mean. I try to convince them they don't want to know that, but sometimes you have to. So you take the total acreage times their share and it'll give you an approximate amount. But then they get confused and run around thinking that that's how much they own, and they don't. I try to stay away from dividing it out into this would be how many acres you actually have, because that's not how they own it. They own it in an undivided interest. Does this make sense? Does anybody else have questions on that? This, for when you're preparing to do their will, this is probably one of the most vital pieces of documentation you can have to help them prepare it. Ask for it, make them come get it, have them talk to us if they have questions. And then what we do as we're finding out that they're working with an individual that has, that's gonna prepare it, we just get them to give us permission to fax that document to them too, so that that attorney or that preparer can have access to it too ahead of time, so that if they have questions, we can't answer specifics, but if they call us and have questions, we can give them general, and we can usually work through without talking about it unless that individual that you're preparing the will for has given us permission to speak to you and answer specific questions for their allotments. So.
I have a question that's completely separate from this, and I apologize, but it's something that I think that needs to be asked. I've been doing separate training because of my dad. He's a veteran, and I've been doing it for a while now. And has anyone spoke to anyone about veterans' pension benefits and pension trusts, and will it work with?
Okay, remember, you can't put a trust in a trust. But we have reached out, we are starting to reach out so that when, it's our hope that we'll be able to partner such as this, so that we can ensure that when veterans are doing theirs, or when active military are preparing their documents, that we can get this.
65 and older veterans, so that they can qualify for like aid and
But
attendance.
remember,
That's why I was wondering what the.
and Judge Waits probably, and Deb might be a little bit better, but
Okay.
remember, it's in a trust already.
What's
The
in the
manager,
trust?
the Indian land is in trust, managed by the
Right.
United States government. The IIM account is gonna go out directly to them unless they've asked us to hold it or they're a supervised account. So that'll go into whatever banking account they have, which will fall under what you're preparing for that individual, unless it's staying in the IM account. And most of them will go out unless they have it on voluntary hold or are supervised an adult. You can't attach the Indian trust land to those. Nobody can come in and take it. And remember too that the income that's generated, oil and gas, farm pasture, etc., is it's not taxed. So for IRS purposes, you're not going to have a 1099 that's generated. The only time that would happen is if you have accrued interest that is generated off that income. But
So that's not a bad thing.
Nope.
Qualifying for aid and attendance.
yeah, you have to talk to each agency though and have those experts tell you what the balance that's generated how it affects it.
Right.
But as far as the land itself, it cannot be attached to anything.
Does it have to go into the trust?
You
if it's
can't,
not?
because you can't put a
Well, I'm saying
trust-
it wouldn't have to then maybe.
No, and remember, it's not going to be part of those pieces because
Mhm.
it's not managed by that person. It's in trust. It's on the reservation
already-
and in trust.
Right.
It's already they can't, because normally when you're doing that, you're putting it in there and it's going to pay for a benefit, or you're going to put it in an irrevocable to have it. If it's 3 years or 5 years
No,
before.
there is no look back with aid and attendance.
No, it didn't.
No, that's why I'm wondering if
This
it'd be a
can't-
great piece for,
Yeah,
The-
this Indian trust can't be put anywhere else, and nobody
Which is
can
great.
come in and
so,
force that to be taken.
so are there Indians that are getting the aid and attendance that should be getting it?
I don't know, because we
Okay.
we don't necessarily see that end of it coming
It would
in.
be a great source.
Could
for
be,
them.
yes, could be very.
And it might need to be looked into maybe.
Yeah, I'm just not an expert on that. I just know
Okay.
that the land is protected
Yeah.
for it. And you
So
can't put any.
You might not need to worry about the VAP, but you could still worry about getting the application and all of that kind of stuff done.
Yes, yes. And in that case, there's
It's an underutilized resource for them.
Right.
That's what I'm maybe.
And that's where they're gonna use their legal advisor to help them work through it, and then we, as the field, can be the expert to explain Indian trust land and what it is, but we're not going to be, we won't make decisions or give advice with regards to that. We'll just give the information, we'll educate on that, and then that'll be something that the person that's helping them achieve that will have to be working with their counterparts to ensure that it's being done correctly.
Yeah.
Yeah, because we don't give advice, we'll just give you all the information you could possibly take from us, and then it's up to you to go ahead. And then just remember, be direct, because there is cultural differences, and sometimes if you're not used to working in Indian country, you can be a little hesitant. Be direct, clearly state what the requirements are for the appointment. They need to come ready, they need to have their decisions made, they need to have the paperwork there, or you won't be able to fill the appointment, because you need to have that ready. Remember that Native individuals are very much visual communicators, so stories, descriptive versus black and white, will help them understand what you're trying to get at. And remember, you're providing the service, they're the clients, so that it's okay to make the requirements out there in order to make the service, because you are providing it. And for a lot of you, we know you're doing that pro bono to them, and so that the time that it takes for them to make their decision at your desk really isn't available to you. So just let them know what you expect. And then always tell them that they can come to the field too, and we can do that footwork, the before footwork, the explanations, getting them prepared, reminding them what they need to. We do that every day, all day long. And then I'd like to turn it over to Francis. Thank you. Hopefully this part was informative.
I'm Frances Gary. I work for the Confederated Salish and Kootenai Tribes. In 1990, the tribe compacted the functions the BIA does as far as the land operations. I am the probate specialist there, and we write wills along with my partner over here, Kay Decker. Wave. And anyway, in 2002, the council created the Tribal Lands Department, and in that department, we maintain permitting and leasing, land planning, land services, and we have the first tribally managed title plant. We were the first in the nation to have our own individual title plant. Currently, our council has approved that Roberta and I can continue to do wills, but only in special cases. That being that the person has only trust land on the Flathead Reservation. They can't have it on another reservation because we wouldn't necessarily know their codes or what might affect their land. And that they also do not have any taxable properties because we're not trained in how to do anything with the taxable properties. That's what all of you are doing. And if they have home sites on the Flathead Reservation, we can do those wills as well. Our tribe is what we call an IRA tribe, an Indian Reorganization Act tribe, and there are several of those throughout the nation. That kind of limits how a person can leave their land. They can't transfer through their will property out of trust. So that's one big thing as far as an IRA tribe, you can't do that. Okay, information that we provide to assist the clients in making their will. Of course, the other girls have already talked a lot about that. We provide the ITIs, the ownership reports. With our title plant being on site, it's really easy to pull up those reports right away. We can pull them up for any reservation as well. We're just not limited to just pulling up Flathead's information because it is a national system and we're locked in with our title plant. And we can provide the income reports as far as what kind of income they're making on their properties, because a lot of people want to know how much they're passing on to each individual kid. Some properties bring in a lot of money, others don't. So that helps them in making that decision. We can also check the IIM accounts, and this can be important for me being a probate specialist. If they've got a few cents in an account and they die owning that few cents in an account, we've got to probate them. And I've done several probates for less than 10 cents in that account. So if they know it ahead of time, maybe they can wipe their account, get it cleaned out, cash that check, because otherwise it's going to go back in their account. And that goes for the heirs too. If they're inheriting, they're going to have money in that account, and if it's not over $5, it's sitting there forever. So it is really helpful to advise those people to check on their IIM accounts ahead of time to make sure if they're small accounts, get them cleaned out and cash those checks.
So if we have a client come in and they have 10 cents in their account, can they request that that
Yes.
be distributed?
Yes, they
Yeah.
can request that it get distributed, but don't save that check on the wall, and because we have had several that have done that. And, oh, well, we thought it was funny, so we framed it and put it on the wall. Well, it goes back in the account and I'm doing your probate. You know, so in helping get them to cash those really is important. One of the things that on that ITI report that she was showing you how to read, the interests down on the bottom where it says A for, you know, it would be all their interests. One of those beneficial interests, you might see an L in that, and that would mean life estate. You might see a D in that, which could mean a dower. Dower rights were done long ago, but they were something that people inherited through probates, but they're like life estates, extinguish at death. So a lot of people get confused that they can pass those on and they can't. They end at their passing. Joint tenants can also be described in there. That would be that they already have somebody that's going to be in line to inherit that, so they can't be passing that on either. So those are things that you'd want to look for on that ITI. With the changes in the laws that have occurred over time, a lot of individuals are really confused about how they can leave their property. This happens almost daily, that we hear somebody saying, well, I was told by somebody I can't leave to my descendant kids, that they're non-Indian, and that's not necessarily true. You can. And it's trying to get those things straightened out in their heads, that sometimes they've been fed a lot of things that, with these changing laws over this, probably since the 90s, that they've really gotten confused about how they can leave their properties. There's also, as far as like Flathead, the home site leases, they can leave their structures on that lease, but they can't leave the lease. The lease still has to, they have to have a person that qualifies for that lease. If they have structures on that lease, yeah, they can leave it to them, but say that on Flathead, they have to be enrolled to hold that lease, or they have to meet certain restrictions. They can't have more than one home site. That's
So you're saying they
so-
can leave the building?
they can leave their structures, their
any
improvements.
descendant, but only, the lease can only go to someone who qualifies by tribal rules, like,
Right.
such as they're enrolled or...
Or else they're given so long to liquidate that asset when they pass, their heirs are. Or to get it to somebody that qualifies for that lease. So, again, that's, you know, they're not leaving that lease. It's a wish that maybe somebody hold it, but they're not leaving it to them. They still have to qualify.
Oh, so they can leave it to a person they think qualifies?
Yeah.
If that works out, it works
Yeah.
out, but otherwise, it has to
Yeah.
be someone who qualifies, and they could be
Mhm.
wrong.
Right. So they're still gonna have to meet those qualifications. Also in the wills, to make sure that you address not only their land that they hold in trust, but their structures and how they go their improvements. Because if you don't say who the house goes to, then it could really get messed up that way, because we're dealing with more than one court now. That house is being probated over here in tribal court or state court. That trust land's being probated here in federal court, so we're crossing two lines there and want to make sure that they end up matching. A lot of times I run into people wanting to do they'll do their wills and they want to do things set up their trusts. Well, of course, as the other said, do not do trusts on trusts. The land's already in trust, you can't do another trust on top of it. We try and give all of our clients some options as to what they can do to prevent the probate. And that's with this estate planning, when they're doing their wills. Options that we can would suggest is maybe gift deeding prior to their passing. A lot of the older people, that would work out. They could retain a life estate and they can use it until they're passing, but it's already passed then to somebody else. They could create joint tenancy, where when they pass, then it's just going to go on to the survivors that are already joint tenants. They could also sell to other owners that own in the property as well. Let's see. On Flathead, one of our rules too is that if they did do this selling or this to other persons, the tribe does have first right for purchase. So they would have to go through a process to have that approved or disapproved by our council. Another thing that when we do will writing is we try and ask them to provide their documentation, so the probate process is a little bit shorter. Providing like marriage certificates, divorce decrees, copies of their descendant children, their birth certificates. Flathead does have keep all of the birth records for enrollees. So we can collect those, but it's the descendant kids that we're not able to get those documents as easily. If there's a death or if like I said, if there's an adoption or a name change for a child, somebody like that, those records, when I have to do that probate and get it ready for the judge here, it'd be handy to have those on file already. So it would be encouraging them to at least talk with their individual probate office, their tribe, to see what would help to make that process a little shorter. A lot of times people think that, well, I did my will, so I don't need to do all this other stuff, provide all this other information. Well, the things that we provide for the judge are two different lists. We provide a list of heirs at law, and we provide a list of beneficiaries. And that's where all that extra information is needed. Just because they have the will doesn't mean it's going to go that smooth as far as my part of the job is collecting all this information. It's still got to be done. Of course, those records aren't necessarily, that you have to have them to do the will. But it helps me. So anything to help me or any of the other probate people that have to collect all this information, it's really helpful. And I know working with these gals, sometimes they'll want a release of information form done so that that information can be passed on to the people preparing the documents. So possibly getting that release in order with your client would be really helpful for you. And doing the will intake type form where you even write down some of this information, and I think once you get your book, you'll see that there might be a will intake form example in there that kind of documents some of this information. It makes things a little easier down the road for the preparers. Also, in Flathead's case, I don't know if some of the other tribes are this way, they may have burial benefits. We have a form that our enrolled members can fill out. It's like an insurance form, basically. You select your beneficiaries, but there's a $5,000 burial benefit. So they'll cover up to $5,000 in that burial. If they don't fill out that form and say they didn't use the full $5,000, a little hard to do now, but if there was balance left over, that's going to end up in tribal court for probate. So that's another thing to ask them if they're Flatheads or if their tribe has a burial benefit program that they need to sign up for.
And they have to have signed up in order
Yeah.
to get the benefit.
Well, no, they'll still get the benefit. It's just that without that form, they don't know who to deal with. And if there's a balance left over, it's going to go into court someplace to be probated, at least for Flathead. They still get the full $5,000. Okay. Oh, one of the things that we do at Flathead is we do still retain the wills if the person chooses. We have a fireproof vault within our fireproof vault that is limited to the access of myself and Roberta to access these wills. Once a person passes away, we'll get a conformed copy for our tribal court, which they will work with as far as structures. The last thing is some of the others had already talked about some of the cultural approaches that may be very important. One of the things I had run into with actually with the Navajo was that, and there's other tribes that are this way, shaking hands when you greet somebody coming to you. I kind of let them take the lead, because if you put your hand out there and you go to shake the hand, sometimes you don't apply pressure to their hands. You just basically touch and that's it. It can be a sign of disrespect to those people, and then they won't talk with you any longer. So sometimes talking with some of the other reservations before you deal with their people is to see if there's any cultural things that you need to be aware of before you deal with them. And there's plenty of people at the different reservations, the different agencies, the fiduciary officers can get you in touch with to help guide you through that. And also with the interpreters, there's every reservation has at least somebody they can get if you need an interpreter. One of the mean things I did, I guess, when we first started, my other half, who's full-blood Navajo, came in and I told him, I said, go in and start talking your language. Well, that threw everybody off course, and everybody was running for the hills like, what do we do with this guy? And he continued to speak only his language. And that was where, again, I thought, okay, you should have asked about an interpreter. So it is something to be aware of, and there's several reservations where people only speak their native tongue still. And pretty much I think that's it. So have lunch.
Question.
Oh.
You have a fractionated estate, and one of the owners of that estate refuses under any grounds to sell the entire property. What do the other owners in that undivided estate have to perhaps force a sale?
Nothing really. I mean, they can't force them to sell.
Cannot.
You can
No.
only sell your undivided interest.
Yeah, you could only sell your share.
Only your share. You can't force anybody to sell to anybody. You can only sell your undivided interest.
Which in many situations would make the property unsaleable.
Pretty much,
Yeah,
but,
nobody's gonna buy a 1/54th interest in a
Right.
piece of property.
Outside of Indian country, yes. On the reservation, no. They'll purchase it. A lot of the tribes have their own land buyback, like Northern Cheyenne has an active land buyback. The tribe will purchase it. Co-owners will purchase. Abra has a co-owner purchase. So your undivided interest is yours and you can do it. And you, in Indian country, you can find usually a buyer.
Thanks.
yeah, some of our older tracks on Flathead, pre-APRA, they could leave their non-Indian spouses or adopted children that were non-Indian received, and then fee patents had to be issued for these undivided shares. So you may find a piece of property that is a little fee, and the rest is in trust. Well, you get these fee owners coming in and thinking, well, I've got a quarter interest in this, I can build and I can, it's not a good thing. We've had land sharks picking up some of these fee interests in county, and they have no control. The trust interests in that.
Thank you.
So,
Francis, I've got a quick question. You've mentioned to me before, and we've looked at the maps that you had, and I know that the Flathead is really checkerboarded, and you've just mentioned the fee lands and the trust lands kind of intermingling, it seems to me. And Deb had mentioned mapping, and Carrie and Lynette also. And is there a way that we can access some of those maps online? So that when I'm doing documents with someone and they're talking about, I mean, I can look like at the Fort Peck and it says it's BIA, but it's just a big swath of orange.
Yeah,
I don't know. It's,
it was interesting with the land buyback program, when they sent out offers, they sent out little postcards and it kind of had the general, like a Google map. But generally, when I'm looking for maps, I'll go through the tribe. They have a GSA, they have a
yeah,
program.
GSA.
I don't know how you guys generally do it, but I know Google Earth, sometimes you can bring it up. Of course, that's not the official.
Right, but it would have just at least give me a point of reference when I'm visiting with them.
Well, and beneficiaries can get copies from the BIA for the non-compacted contracted tribes. It would be the Bureau would have those. I don't know. I don't know if they give them out.
I think they give them out to the public,
Yeah.
like reservation-wide. I don't know of that.
Okay.
Yeah.
And really, the only way I discover that is not through intake, but
Yeah.
actually going through the tracks with them and talking about what they do with them, and then we discover.
One thing that might be helpful for that is if they feel like they have fee interest on it, they can get what's called a TSR, and that'll list all the owners' interest and how it went out of. We don't, once it goes out into fee, we don't keep track of owners, but at least it lets you know that that piece is fee ownership. So that's possible to get. It's not a map, but it at least would let you know.
Okay. And the reason I ask is because sometimes I've had people who say it's fee land, but they're not really sure.
Yeah, that's where they would have to request a title status report.
Yep.
And it'll indicate it on there.
Okay, thank you.